Good evening and welcome to the Supreme Petition. My name is Joe Agale. The country is counting down hours to the moment the Supreme Court will give its final verdict on the 2017 presidential election. By Friday evening, Kenyans will know if they will go back to the polls or if Uhuru Kenyatta will be sworn in for a second term in office. How will the judges rule? Will the court's decision in 2013 petition haunt the current bench? We have two advocates in studio tonight, Martin Olo and Mudhomi Diankolo, and we'll be speaking to them in a short while. But first of all, I'd like to bring my colleague Sophia Wanuna, who is at the Supreme Court. Actually, Sophia, nothing obviously happening there, but so much to look forward to tomorrow.
Indeed, Joe, not much happening here tonight on the eve of Judgment Day. And as you said, Kenyans will know which way after the judges of the Supreme Court deliver their judgment tomorrow. A lot of anticipation, a lot of discussions as well around that. But we expect by tomorrow afternoon, the judges will come here at the Supreme Court and deliver that judgment. And we hear as well, as we have seen before during the hearings, Raila Odinga and Kalonzo Musyoka, who are the two petitioners in the petition, will be present at the courtroom tomorrow, Joe.
Now, Sophia, obviously, I'm sure you've been speaking to a number of people, speaking to lawyers and whatever sources you have out there. There's this thing, the 2013 petition that has been in the air, a lot of people talking about it and how much, if at all, it might influence or not what happens here. What are you hearing, the kind of conversations people are having in those circles with regard to this year's petition and the 2013, especially now that we're just hours away from the ruling?
Yes, Joe, that is one that has heavily been discussed. And also, we saw come up in the courtroom with all the parties talking about it because the decision then ruling and finding against the petitioner, who as well at the time was Raila Odinga, was that there was not sufficient information or evidence brought to the court to show that those discrepancies that were highlighted would have changed the result anyway. And what we've had the petitioner argue this time around in court is that they have been able to bring evidence that shows there were discrepancies, irregularities, breaches, if you like, in terms of how this election was conducted. But they have argued they should not then have to prove that that has a bearing on the final result. In essence, asking the judges of the Supreme Court here to overturn and go back on the decision that was made in the 2013 presidential election petition. However, the respondents, all three, arguing that the judges should uphold that jurisprudence, should ensure continuity. We even heard the Attorney General, who was a friend of the court, address and submit the court in regards to that. So on those two sides, a lot saying 2013 is critical because then we'll wait to see, will these judges decide to go with the thinking, to go with the guidance of the 2013 Supreme Court, or will they reverse and in essence agree with some of the submissions we heard from Paul Mwangi appearing for the petitioner, who argued that the 2013 Supreme Court misinterpreted the law, that instead, and even talking about the conjunctions and or, that the court used and, in essence saying they should show as a petitioner there were irregularities and show that those irregularities had an impact on the final result. Paul Mwangi arguing the law says it should be either or, not and. And of course out here as well, you can imagine many Kenyans discussing as well the same. But it's important to note, because that came up in a discussion we were having earlier, and some lawyers said as journalists we need to highlight this, is that whatever way the judges rule tomorrow, there is no way they could either, of course, uphold the election of Uhuru Kenyatta, but if the petitioner manages to win in as far as being successful in his petition, that does not mean he then becomes president. I think that's a very important point to note, because for some, it has appeared in several forums that they think if the petition is successful, it means immediately or automatically Raila becomes winner. It would perhaps mean an election in 60 days, Joe.
Yes, Sophia, and that's a very important thing you bring, and that's why we do this show, so that people can completely understand what this really means, that in fact if the petition were to succeed, then we still have another election at which whoever of the two candidates does its best could actually still be declared. So it could either go away anyway. But my question, Sophia, will go back to one issue that also has come into sharp focus in light of what's been going on. We saw the last moment of this was really about those two reports. The scrutiny that the petitioner had asked for. In 2013, there was a scrutiny that was done. I have been hanging around many lawyers, and they say on the court's own motion, they had this petition, this scrutiny that was done because the court asked for it. This time the petitioner asked for it, and the court granted it. And there was quite some discourse going on around the place of scrutinies in something like this. What are you hearing out there?
Yes, Joe, there has been a lot of debate on whether, in fact, the two reports that were presented and submitted in court will have a bearing on the judgment we hear tomorrow. And what we're hearing from the lawyers, we are speaking to one of them, in fact, pointing out a book, Balancing the Scales of Electoral Justice, and it really discusses elections disputes. And one of the articles in this book is by the current CJ, David Maraga. At least the byline indicates it was written by David Maraga. And it's a critique of the 2013 judgment in the sense that the issues, beg your pardon, the application at the time, actually it was not an application. The scrutiny that was conducted in 2013, as you said, it was the judges by their own motion who decided to have that scrutiny conducted on the statutory reforms at the time, and also some of the ballot papers. That was not seen. The reasons as to why the judges decided to go that way was not seen in the judgment at all, the objective of that scrutiny, and also the results of the same. So many of the Supreme Court, parts of the judges that they deliberate, it is very likely that they would be considering the results from the scrutiny exercises, the two reports that were placed before them. And remember, those were exercises that were conducted and overseen by the officials from the Supreme Court, Joe.
Interesting, but we have to emphasize, of course, that when those two reports were presented, each advocate appeared to think, or at least that's what they told the court, that it supported their respective clients' positions. That was a very interesting thing to watch, considering that it was the same report, but each side seemed to see it from a totally different side. But Sophia, finally, the whole question of when is this ruling going to come? Do we know anything? Have we seen any signs that whatever, have you seen anything that could perhaps give us an indication whether we're going to have this thing at 7 in the morning or whether we're going to have it at 5 p.m. or something in between?
Right now, Joe, we still fall back to the fact that the Chief Justice is an SDA, and of course Sabbath begins to be marked from Friday 6 p.m. to Saturday 6 p.m., meaning we cannot work after 6 p.m. tomorrow. So it is likely we'll be having what we'll wait to
we find there. But in the meantime, we can have a conversation here. At least I have my guests. I know what time they were supposed to come, and they're here. So, gentlemen, thank you very much for joining me. Martin Olo, Mudhomi Diankolu. Just how significant is this thing that the judges are going to do tomorrow? Paint for me a picture from where you sit.
It is perhaps the most significant case, Joe, but not just for the reason most of us think it is significant in the sense that it relates to the most important office in the land, but its implications for electoral justice in this country, so that this matter is not just one between the antagonist or protagonist. Petition as a matter of law is deemed to be what lawyers call a matter in rem. That is to say, it is a matter affecting every citizen, except that because of the adversarial nature of our legal system, it must be fought in the names of particular individuals. I would imagine the decision will have significant political implications, depending on how it goes. It could have serious economic implications. If, for instance, the decision is to nullify the election, it means
Nyangos and Kiplangats and whoever else is out there is really concerned about this lofty thing of, you know, electoral principles in the country. And I mean, a lot of people see this as a purely political thing going on, right?
Yes and no. I think most Kenyans know that they voted, and they have every reason to believe that their vote counted. And so what is happening is they want to know whether it's their vote that carries the day or something else is said about their vote. So basically it's about numbers, it's also about the truth, it's also about justice, it's also about what is it that we're looking for in terms of transparency, in terms of accountability and responsible governance. So the Kenyans out there know that where we are at is a process. We came from a time when presidential elections were unquestioned. I mean, they were final. And whoever won it. And even to try and serve against the president at that point, if you had a petition, you found nowhere to serve. And at that point, it was personal service, so you couldn't get the person. We've since evolved to the extent that we've put in our constitution an anticipation that in the event of a dispute around the presidential elections, that matter will be handled by the Supreme Court, and the decision of the Supreme Court will be final. So we have prepared ourselves mentally.
But which stage are we at? Because it seems to me that quite literally every election, except 2002, has been controversial in one way or another, or certainly to varying degrees. I mean, the times you talked about, there are people who tried to mount some kind of petition, even though the legal environment, the political environment didn't quite make that easy. But even subsequently, after the horrors of 2007, we saw 2013, there was a petition. This time there's a petition. Is that saying anything about something about our electoral system?
Certainly.
We just love going to court?
No, Joe, certainly we are evolving. And I think we must also congratulate ourselves and thank ourselves. Because remember, in 2007, we had no mechanism to resort to because we did not have systems that we could then reliably resort to. We've since changed. After 2010, with the new constitution, we are saying, fine, everything around elections, including the presidential elections, we can actually litigate around it. So we have a valve, and we tested that valve in 2013. And that valve is still going on to be tested in 2017. And I can say that that's not the end of it. And now, my friend Mudomi says that if there's an order to go back to the elections, yes, we'll go back to elections. But what we are also saying is that should again that election be disputed, again there will be another chance to go to the Supreme Court. So the litigation won't go away just because we are tired. But as long as there are issues to be litigated, there will be reason for us to litigate.
There's no legal end to that, so technically...
It is whether we actually learn anything, because one of the tragedies with the adversarial legal system that we have here is that the courts will tend to rule in favor of one party, and the party whose favor the judgment follows tends to think that they were vindicated, and therefore what they had done was right.
So they can do it again.
Therefore, they can do it again.
But why don't we be a bit more specific here? What would you say are those running issues that are never resolved by the courts? Because I think that, to my mind, the reasons why we take things to court is not only for them to be resolved, but also that the courts might set in place certain principles that you hope then would guide that process, whatever it is going forward.
Joe, this is not a legal problem. This is a social-political problem.
Okay.
And what we are not discussing here is the number of disputes that arose from the primaries, both in the ODM primaries, NASA primaries, and in the Jubilee
But those primaries were badly done. I mean,
exactly.
everybody knows that whether it was Jubilee or NASA.
That's where I'm going back to. What is our general attitude towards election? Winner takes it all. What is our general attitude towards election? You go break a bank, you invest in it. Now, what do you do after you've broken a bank to invest in politics? You must win. So what does that mean? Whatever foul, whatever corners you can cut, whatever breaches you can have, you will go for them because you must win.
But what do you mean winner takes it all? The way our laws are, the Constitution as it is, does not envisage a situation where we go for an election and no one wins. And in our case, if someone wins, the other one has to lose. I mean, and that's not a construct. It is the truth.
Let me put it this way, Joe. And I want to show you the difference between a winner-take-it-all system and a proportional representation system. Where, for example...
No, I'm talking about what we have.
No, but I'm saying that that is our problem. That the nature of politics is so competitive, and therefore we invest in it so hard, and we must then win. So, and if we must win, it means that we must also breach in the process. So, if you make it less if you make it more about political parties, if you make it more about representation, that changes the ball game. So all I'm saying is that the nature of our system is such that we will not walk away from the disputes we're having. And you can see it in the primaries, and you can see it in the major election, and you can see it both in the presidential, whether it's gubernatorial, and so on. So basically,
do you share that view? Because I think that we run the risk of losing a point here that is important, in the sense that I get the impression from what you are saying that maybe a lot of these disputes, right now there are many, I think 28 or something cases that have already been filed other than the presidential one. Are you saying that there might not be an issue in any of those things, that maybe people are just worried about losing an election?
I'm simply saying that the issues have a pattern.
Maybe I can extrapolate.
Maybe I
can extrapolate what my learned senior is saying. The real problem, Joe, and the only area I part ways with them, is we have a socio-political and economic system where the only way you can thrive by accumulating resources is to capture the instruments of the state, whether as an individual or in concert with other individuals. Regrettably, that is the reality of the system that we have here. And the reason our politics is so cutthroat, so much a matter of life and death, it is not because these people are so passionate about serving the ordinary mwananchi there. It is about the incentives, the economic incentives and rewards that come with occupying state office. And that's where now it comes, for me, where the only area I part ways with my senior. Then the question is, how does the law and electoral dispute resolution in particular, how do we structure our electoral dispute resolution and our electoral system so as to ameliorate all these perverse incentives to capture state office by whatever means necessary, if that means is bribing voters, if it means ethnic profiling and killing people because they are in this tribe or the other, if it means doing all the unimaginable things that actually you would not expect would happen in an election. And for me, why I said earlier on that we have a problem with the justice system is that my own understanding is that the purpose of the law is to help a society resolve its socio-economic and political problems.
And I want us to have that conversation. We need to take a short break, but I want us to have that conversation because, to my mind, if something has been resolved by the courts, there ought to be some learning that then means we'll have fewer type or the fewer numbers of that type of case or whatever it is in the future, because there's a principle or something that has been settled that then guides how we move forward. But anyway, let's take a short break here. I'll be back with my panel here, just having a discussion about the ruling that we're expecting tomorrow. What are the possible implications? What are the options those judges have? Don't go away.